Hi everybody. So today I'd like to talk about what happens during a criminal arraignment. A criminal arraignment is the first time that the person who's arrested and is being charged with a criminal offense will be appearing in court. And that first time someone appears in court, a number of things need to happen. So I'll explain to you what usually happens from my perspective. So what I'm going to do is I'm going to be with the client, and the client and I are going to go and we're going to stand where we're supposed to stand. I'm going to put my appearance in. The client's going to stand next to me. They may ask the client if they're the person who's accused of something. They'll say yes. What I'm going to do is I'm going to waive a formal reading of the charges so we don't have to read everything. I'm going to reserve some legal rights on the record, and I'm going to plead my client not guilty. Even if I know they may have done something or they know they may have done something, we're still going to plead not guilty because there is most likely the possibility of negotiation and working out a lesser charge. So we're never going to plead guilty at the arraignment. Even if I wanted to, a judge probably wouldn't accept it because it's not something that's usually done for most things in that situation. A couple of other things are going to take place during this arraignment. They're going to determine if an order of protection should be issued. And that's a topic for a whole other video, but an order of protection could be issued for my client to stay away from whoever the person who's accusing them of the offense is. And the other thing that's going to happen at the arraignment is a custody decision is going to be made. The judge is going to determine if bail needs to be set on the person or if there's some other means of release that they can give them, some sort of tracking, an ankle monitor, reporting to probation on a regular basis, some means other than monetary bail. Laws have been changed in New York in the last few years. There are a lot of offenses that judges can't set bail on, so we know the clients are going to be released, but they might have these other tracking methods. And then once the judge makes that decision, if there's no bail, the client's usually going to leave with me. If there is bail, they're going to go back and we're going to figure out how we're going to pay it. And we're going to put the case over for another day. And between the arraignment and the next day, I speak with the prosecutor and we see where the case is going to go and work it out, hopefully. But that's pretty much the components of what an arraignment would be.